appeal on the matter of Niramax Group Limited and the Zurich Insurance PLC.
Please, my lords.
Mr. Eckland.
Ladies. I appear for Zurich, the appellants in this case, together with my learned friend Mr. Troman. Mr. Ben Alkington, QC, appears for Niramax, together with our learned friend Mr. Ben Smiley. My lords, my lady, can I just say at the outset, thank you very much on behalf of us all for agreeing to hear this appeal in person. We're all very pleased to be back in court, if I may say so, and it saves me having to ask my learned junior to mute himself.
Well, for our part, thank you for asking to be in court. We too are delighted to be.
Yes, I think we're all delighted. But with that, I'll get on with the submissions that I wish to make. Can I just give you an outline of what I propose to do? So I'll make some introductory remarks first, just summarising the case and where it got to. Then I propose to look at the relevant facts by reference to the judge's findings. Then I shall look at the fact that it is now accepted by Niramax and agreed by Zurich that there was no mistake in the premium that had been charged for the disclosed facts. Then I shall look at the correct approach to the questions of inducement and the law. Then I shall consider what the judge ought to have found on the basis of the findings and assumptions that she did make, and then look at the effect of the error which the judge made, which is now agreed, in her assumption as to the premium which had been charged. And then, if I have time, I will make some comments on Niramax's notice and skeleton.
Right.
So that's the framework. So, introductory remarks. You will know that this is an appeal from the decision of Mrs Justice Cockerill, given on the 9th of March 2020. The claim was by Niramax, who was a waste and recycling business, against Zurich for loss from a fire on 4 December 2015. The claim was for some £4.5 million for loss to mobile plant and a large Eggersman plant. My lords, if this is material which you're already aware of, I don't want to traverse.
Well, we've read the skeletons and the judgment below, so I think we're familiar with this part.
Yes. Of significance is that at renewal of this particular policy in December 2014, the property insurers of Niramax had by then increased the excess on the property insurance policy to £250,000 and required Niramax to self-insure for 35% of the loss due to their non-compliance with risk requirements. Lords, it appears to us that in a nutshell, this appeal is about the decision of the judge in paragraph 214 of the judgment. In that paragraph, she found that the only change which Mr. Penny, the underwriter, would have made related to Zurich's earlier underwriting errors, although she had found at paragraphs 211 and 212 of the judgment that Mr. Penny, who was the Zurich underwriter, would have required a higher premium if he was going to insure if he was going to renew, given the non-disclosed facts. The twist to the tail in this case is that after the judgment, Niramax's legal representative rechecked whether in fact there had been a mistake in the underwriting premium which the judge had found, and which as a result of which she came to the conclusion that the causative effect, the cause of the increase in the premium would not have been the non-disclosures, but would have been the correction of the underwriting premium, with the result that the non-disclosures did not cause or bring about would not have brought about change to the policy.
So this is now agreed. I'm a little bit puzzled by this, actually. Is this the respondent's notice point?
What is agreed is that there was no mistake. The judge in 214 had found that there had been a mistake.
Yes.
What is agreed now is that there was no mistake.
So that your client made no mistake.
My client made no mistake.
Sorry, is that because what was charged was not charged in 2014 by reference to the rating schedule, but simply as a 20% uplift?
Yes.
But it remained the evidence that if the rating schedule had been agreed, had been applied, then the 2.25% figure should have been 6%, but conversely, the 1.4 factor, 40% loading, should not have been applied.
Well,
right?
my lord, in effect, yes. But what is now agreed is that there was, in fact, no mistake in the calculation of the premium which had been undertaken by Zurich when they renewed.
Well,
And that-
I have to
And my,
hear from Mr. Elkington on that.
Yes.
But as I understand the respondent's notice point, it's not that there was no mistake. It's simply that the point is the judge was in error in thinking that correction of the mistake would have increased the premium, because if you made the correction to the mistake by putting in the 6% in place of the 2.25 and taking out the 40% loading, you wouldn't have got to a higher figure than 23,700 and whatever it was. That, as I understand it, is the respondent's notice point, and that doesn't, if put in that way, mean that it's agreed there was no mistake in the way that the rating schedule was applied.
well, that may be in the calculation of the way in which the rating schedule is applied. But what I think is agreed is that the judge was not wrong. I beg your pardon. The judge was wrong in finding that the premium would have been higher, and that the premium was wrong.
But, I mean, that's the critical point, isn't it?
That is critical point in this analysis.
But I mean, that's...
Sorry.
Is that not the respondent's notice point? That
Well, there is.
that there wouldn't have been any change in the premium. That, in other words, no error was made in the premium that was actually quoted and at which the risk the policy was written.
Well, my lord, I think that is the critical point. But what emerges is this: that the what was thought to be an error is no longer an error. However you get to
Right.
however you get to it.
Right.
And what we would say is that the calculation that was obviously done in relation to the premium as it was understood was in relation to the facts which had been disclosed. So when Zurich were underwriting the risk, they underwrote it, decided on a premium, applied the premium for what they knew.
Yes.
What they didn't do and what they couldn't do, because they didn't know about it, were the non-disclosed facts.
But how would that have affected the premium?
That would have affected the premium by we don't know precisely how that would have affected the premium.
I mean, the judge didn't find that it would have affected the premium.
No, we don't know precisely how it would have affected the premium. But what one can see when one looks at the analysis, and if I'll go through and take you through it. But what one can see is that all that was factored in to the judge's analysis was that the incorrect premium had been charged for the risk as it had been disclosed.
Yes. And
Therefore,
if there had been disclosure, while that would have led to a correction of that error, there would not have been any additional, as it were, addition to the premium by reference to the non-disclosed material.
She didn't make that finding.
Well, did she not?
She
Because
didn't.
she's effectively said that all that would have happened is that the error would have been corrected.
Yeah, yes, she says that.
Yes, but does it not necessarily follow that, I mean, at the very least, there's no finding that there would have been an increase in the premium?
No, I agree with that. She
Well,
doesn't.
Where can you take this then?
Well, my lord, if I may just develop that.
Well, yes, I'm asking this because this is going off in a direction that I hadn't anticipated. That's why, because I hadn't understood you agreed that there was, that there was no mistake. I hadn't sort of quite, you say it's Niramax who've now tumbled to that, but actually I hadn't realised that you agreed with that.
Well, my lord, it came out in Niramax's skeleton.
Yes.
That was the point that they were arguing.
You'll have to just tell me in a sort of nutshell, therefore, on this basis, where you get to on this appeal.
My lord, what one sees in a nutshell is that 200 through that section of the judgment, 201, paragraph 201 to 214, dealing with non-disclosure and inducement. The judge identifies that Mr. Penny would have required would have imposed a higher premium. That's 211.
Yeah.
In order to write the risk. Then at 212, she says that he would have required a premium which was at or about the right price for the risk.
Yes.
Now, my lords, I would submit to you that at or about the right price for the risk must mean the non-disclosed risk and the disclosed risk. Because the price that Mr. Penny would have required would have been the price for the whole risk.
Yes.
So what the judge has found is that the premium which was charged for the actually charged was too low. There was a mistake in the premium which had been charged. That could only be in relation to the risks which had been disclosed, the facts which had been disclosed at the time of the agreement of the original contract.
Yeah.
And if one then looks at the non-disclosed facts, which were not taken into account at the time of the original contract, then either the judge was wrong to find that there would have been no adjustment, or we would say that in any event, the fact that it would have been necessary to look at and consider the non-disclosed facts would have been an effective cause, even if it would have been an effective cause of the increase in the premium, which would have, I beg your pardon, an effective cause of the terms on which the original contract had been entered into.
But the judge didn't make a freestanding finding, as it were, that Mr. Penny would have charged a higher premium. The process of her reasoning was that if the 6% figure had been applied, that would have led to a higher premium. Leave to one side for the moment whether that's right or not. And that what Mr. Penny would have done, had full disclosure been made, was to correct that error. Now, either she's right in saying that Mr. Penny would have used the rating sheet in order to determine the additional premium, correcting that error, in which case we're into the area as to what difference that would have made, if any, respondent's notice point. Or, if the premium would not have been charged by Mr. Penny by reference to the rating sheet, there is no finding by the judge that Mr. Penny would have charged a higher premium, and indeed no evidential basis for saying that he would, is there?
Well, certainly there's no finding that he would have, well, there is reasoning which identifies that he would have required a higher premium in order to renew. That's in 211 and 212. She then jumps to 214, in which she finds that the calculation of that higher premium would have been by reference to the undercharge because there'd been a mistake which had been made. Now, when one takes out of the equation that there was no mistake, one is left with identifying that the premium which was charged was the correct premium for what had been disclosed. Then, if one looks at the judge's reasoning, that Mr. Penny would have required an additional premium, would have imposed a higher premium for the additional risk, and would not have been so challenging.
But I don't think that is her finding, that he would have imposed a higher premium for the additional risk. The fact he looked at it would have given him the opportunity of seeing that the premium was too low because an error had been made. Yes, that's how I read the judgment.
My lord, but the only reason that he would look at it would be because of his finding out about the non-disclosed fact.
Indeed. That's absolutely right. So it would have been escalated to him. He would have had a look at it. This doesn't seem to be right. This is on the hypothesis there was an error. He would have looked into it, seen that an error had been made in the pricing, and would therefore have said, we must correct that error. But that was an error that existed even with the non-disclosure.
Yes, well, my lord.
So therefore, the logic is that if there hadn't been a non-disclosure, still all that would, well, it's not the logic, it's the finding, that even if there were no non-disclosure, the only change to the premium would have been to correct the error. Now, I don't see how you can deduce from that there would have been any change to the premium at all.
Well, my lord, what even if that is right, let's just assume that is right. Well, one then still has to ask the question whether or not the contract would have been entered into on different terms.
How would the terms have been different?
Well, the original contract, which was entered into, was on the basis of on the basis of a particular premium, which took into account the disclosed facts.
So when I said that what the terms would have been different, you mean the premium would have been different?
The premium would have been different.
Well, that's just to repeat I mean, that's what we're focusing on.
Yeah.
And when you say it took into account the disclosed facts, it didn't take into account any disclosed or indeed undisclosed facts about attitudes towards risk management, because it was based on, so the judge found, whether rightly or wrongly, what I might call a formulaic approach, streamlined approach to underwriting because of the costs involved, in which there were these three factors which essentially determined the premium. So that although there might have been a more sophisticated intellectual exercise to be performed by Mr. Penny in deciding whether to write the risk at all, which might well take into account attitudes to risk. Once a decision had been made that the renewal would be written, then in terms of rating it, attitudes to risk played no part in Miss Jones' thinking, and on the judge's findings would have played no part in Mr. Penny's thinking.
I'm not sure that I would accept that.
No, well, you don't have to. I'm putting it to you as a suggestion.
I'm not sure that I would accept
but
well, Lord, can I come back to my submissions?
yes, all right.
Yes, all right. But I think we have sort of taken time on this because I think we are a little taken by surprise.
Well, I'm sorry if you are taken by surprise, but
Right.
So
Anyway, yes, to come back to your submission. Yes, certainly.
So what I wanted to do very quickly, if I may, is to take you to the relevant findings of fact relating to the risk itself. And if we can pick that up in the judgment at paragraph 53 to 57. I'll take this reasonably quickly. This 53 just begins the history of the requirements for the risk requirements. It's in February 2014 when to remind you, the renewal was in December 2014. 3 risk requirements at Washington. These were never done. 55, 7 risk requirements for Tomlinson Road. That was the major location. And the first 56, requirement 6. Perhaps the key requirement for the purposes of this case, says the judge, stated 3 times, fixed shredders within black sand building. It was necessary to protect shredders by means of an automatic fire suppression system. That was not done either. That was outstanding at the time of the renewal.
You say in paragraph 54 that none of the Washington site requirements were done.
They were none of those were done.
Well, number 3 was not identified as one of the outstanding risk requirements, even at the time of the imposition of special terms, was it?
I think,
as I understand it, at least from what the judge said, is that what was outstanding in October when the special terms were imposed were 54 Roman 1 and Roman 2.
well, as I think if one looks at paragraph 63, she refers at 63 to there being 2 key risk requirements outstanding, that requiring installation of the automatic fire suppression system and the shredders at Hartlepool, and the installation of the CCTV coverage in Washington. The fire detection and the IEE certificate at Hartlepool remained outstanding. And then at 146, the impression given, particularly in the light of the decision not to seek to renew cover for the Washington site because of the cost of compliance with the risk requirements and the training of the firewood, quote, by Niramax in the context of Mr. Sweeney's valiant attempts to get the risk requirements and special conditions dropped, is that Niramax were unwilling to spend the money involved in the risk requirements, and that unwillingness led to a state of drift. Lords, my lady, the renewal of the policy runs from paragraph 99. And she says, and then at 100, the figure calculated for the premium was £23,000. That was a 20% increase on the premium for the previous year. Renewal terms were offered. It was also not an issue that the premium was incorrectly calculated. Instead of applying a 6% rate, and a rate of 2.5% was used, then weighted by 40%, which self-evidently left the premium below the level it would have been if 6% had been used. I think that is the point that Niramax make, that now it's accepted that the premium itself, at least however it was calculated at the time, was not incorrect. And then at paragraphs 141 to 147, we see her findings about as to the summary of as to the failures to comply. And one looks at those 144. in essence, her finding that in relation to the fire, that nothing was being done. There was still more unimpressive period over the summer of 2014, when either Mr. Sweeney was lying to Millennium, telling them that the risk improvements were done. She regards it's more likely Mr. Betts, with no real knowledge, was making positive noises about them progress to Mr. Sweeney, who then counted as done that which ought to be done, the way that he put the matter to insurers. On either analysis, Niramax were being chased on this and were doing nothing in practice. 145. In the autumn of 2014, there was very little sign of activity from Niramax, even in the face of repeated chasing from Millennium and repeated and increasingly emphatic chasing from Mr. Sweeney. There was in reality no good reason why the risk requirements would not have been complied with well before Millennium was driven to imposing special terms. 146. The impression given, particularly in the light of the decision not to seek to renew cover for the Washington site, because of the cost of compliance with the risk requirements and the trading of the file with a quote by Niramax in the context of Mr. Sweeney's valiant attempts to get the risk requirements and special conditions dropped, is that Niramax were unwilling to spend the money involved in the risk requirements, and that unwillingness led to a state of drift. And 147. In those circumstances, I reject this submission, skillfully advanced though it was, that Niramax was actively engaged in compliance, and that therefore, to the extent that the failure to comply would otherwise be material, the failure to comply in special conditions were not material. And then she goes on in her findings between 156 and 158 are the principal findings in relation to materiality. 156, however, while it was in the end apparent in the context of other aspects of the case, both experts themselves took the view that materiality was a wider concept than matters relevant to risk. Here their ultimate agreement on this point was based on a view that failure to comply with risk requirements and the imposition of these special terms in these circumstances was material because, absent active engagement, it manifested an attitude to compliance which was relevant to risk. And then in 158, and of importance in our submission, second line, risk management, which is what compliance with the risk these terms was about, must logically be relevant to risk. As Mr. McElduff put it, that's the Niramax expert, the failure to comply with another insurer's requirements is a grave concern because it speaks of poor housekeeping. And good housekeeping is terribly important because it leads to a higher risk if it is not. Mr. Coates' view was similar. The delay in compliance with the risk requirements went to the heart of the management of the risk. And my lords, my lady, that then, so materiality was dealt with, and the judge then went on to deal with inducement. And I think we can pick that up at paragraph 201, on page 78 of the bundle. So as the judge says, 201, this brings us back to the critical question of what Mr. Penny would have done. He says, I weighed his evidence very critically in the light of the concerns which I've expressed. In the end, I've concluded it's more likely than not that if he'd been aware of the facts in question, he would have reluctantly offered renewal terms in December 2014, but would have refused the extension to cover the Eggersman plant in September 2015. Now, there was no appeal from the refusal to cover the Eggersman plant in 2015. Then she goes on analysing the evidence and reflecting it and comparing it with what the experts said. And then at 206, so to commence with the December renewal, on this hypothesis, the renewal is referred to Mr. Penny. He would at this time have been presented with a great deal more information than was actually presented to Mrs. Jones. Ms. Jones being the
trainee,
the more junior underwriter
Yeah.
who had underwritten the risk. Such disclosures, and he says to Ms. Jones, that is what would have been presented to Mr. Penny. Such disclosures would ordinarily be made on a fair presentation of the risk. He would have been told about the history of the risk, good and bad, including the imposition of the risk requirements and the imposition of the special conditions. He would also have been told that as at the 14th of December, all the Tomlinson Road risk requirements had been met, with the exception of the fire suppression system. And it would doubtless also have been made clear to him by Mr. Sweeney that there had been a degree of confusion about what was required. And what the learned judge omitted in relation to what he would have been told was that the risk requirements at Washington had not been complied with. She doesn't refer to that. I think the reason for that is that when it came to it, Niramax decided that they were not going to renew the property cover at Washington, because the risk requirements were too expensive to undertake there. And I think that's probably the reason why the learned judge doesn't refer to it. But it remained the fact that in terms of evaluating the risk from the point of view of not having complied with the property insurer's risk requirements, Washington had not been complied with. So 207, against this background, would Mr. Penny have refused to underwrite the risk? This is not an entirely easy question. It's largely been presented to me as a binary question, right or not right. On the evidence I have heard and considered, I'm far from convinced the real answer is so binary. I am, however, fairly firmly persuaded Mr. Penny would not have refused to write the risk outright. There remains a question as to what the terms of that underwriting would have been. So that's the first indication in our submission that she thinks that there would be terms associated with the underwriting of the risk. And we would submit, independent of any mistake that there might have been in the original underwriting of the risk. This is the terms which would have been applied if he was prepared to take on the risk once it had been disclosed to him, the full risk had been disclosed to him. Certainly the question was not as cut and dried, however, this is 209, as presented to in Mr. Penny's statements, which did see the matter as one of clear refusal. It seemed clear to me that the full hypothetical was different from the somewhat limited hypothetical which appeared to have been the basis considered at the time when Mr. Penny made his statements. The atmosphere created by the morphity was not split out, considered by Mr. Penny in this way. 210. Overall, my conclusion is that Mr. Penny would have thought long and hard about whether to refuse renewal, but would not have done so against the background where the assured was one of long standing. The story of the risk requirements was troubling, but somewhat nuanced, and the only outstanding item was one where the information given to the assured had been unclear. Well, that's not quite correct, because there were outstanding items in terms of the risk requirements at Washington. This may well have been even more so out of a sense of fair play, given that the risk had not been well underwritten for years. And then 211 and the following paragraph, 212, are obviously of considerable importance. What has troubled me is whether against this background the premium he imposed would have been higher. She says, I have concluded that it would have been. Now, in our submission up to that point, the learned judge has decided that for the purposes of writing the risk on the basis of the non-disclosed facts, Mr. Penny would have done, but the premium would have been higher. That must be the premium which had been charged in relation to the disclosed fact. So what we're considering here is what he would have done in relation to the non-disclosed fact. Mr. Penny reviewed the risk after
What
the
about,
event.
you missed out, that is a conclusion which appears to find support in the independent evidence. What is the judge referring to the expert evidence there?
No,
What's that referring to?
I'm sorry?
What is the independent evidence to which she's referring?
Well, I think the independent evidence is what happened in September 2015 when she came, when Niramax asked for the Eggersman to be added to the to the policy, and at that time, Niramax, I beg your pardon, Zurich, were very reluctant to add it to the policy, but did so by increasing the deductible and imposing a quite significant premium, and also limiting the period of the insurance.
But it was a
for the
quite
next
different. It
renewal.
was a quite different risk in many ways from that
And it
which
was.
had been written under the renewed policy from year to year of the mobile plant. It was a huge bit of new equipment. It was
Yeah, indeed.
vastly greater, and it was fixed plant, which
And it was
wasn't
fixed
something that Zurich would normally have written. So that the considerations in September 2015 can't really be
Well,
used. And I don't see that the judge uses them anyway, does she, to inform these conclusions? And I'm not sure how they could in relation to additional premium and in relation to renewal of the mobile plant policy in December 2014.
well, I think that was I don't think there's a specific reference at this point to that, but the conclusion that appears to support the independent evidence. The independent evidence, I think, is also what she's referring to subsequently in this paragraph,
I see.
Yes.
which is what she understands to be the error in the calculation of the premium.
Yeah, I see.
Yeah.
Okay.
He went on risk. Well, we can see what she says, but that of course falls away when one knows that there was no error in the calculation of the premium.
Well, I know, but
So
that's the point. What happens then?
so too, therefore, is her conclusion that there would have been any increase in premium.
Well, no, not.
The process of reasoning is, if one puts together paragraph 100 and paragraph 211, is that the premium would only have been higher because the error would have been corrected, and the correction of the error would have led to an increase in premium.
Well,
that's the process of
well,
reasoning.
I think what one has got to focus on is that the increase in the increase in premium has got to be as a result of the non-disclosed facts, the non-disclosure. The premium which she thought was an error, and which is now known not to have been an error, was in respect of the disclosed facts. It must have been.
Yes. Yeah, I'm absolutely.
Yes.
So, what the learned judge finds is that the premium in respect of the disclosed facts was an error.
Yes.
And she comes on to find that there would have been an increase in the premium to take account of that error.
Yes.
My Lord, that increase is brought about, in our submission, by the fact that there were non-disclosed facts which were taken into account by the judge, and which she found Mr. Penny would have imposed a higher premium
Well, that's the difficult. Where do we find that in her judgment?
Well, we find it in 211 that in order to insure, he would have imposed a higher premium.
Yes, but I thought you accepted that was supported by the independent evidence, which is what she then sets out in the rest of paragraph.
Well, I don't.
11.
But the independent evidence is what she sets out
Yeah.
in the following paragraph is
Fine, yeah.
now known to be wrong.
Yes, but so we're asking. We've got another hypothetical. What would the judge have decided if she had realised there was no error?
Well, my lord, we don't know that because she doesn't realise that there was no error. What we would submit is that she was wrong not to find that the reason for there being an increased premium would have been the non-disclosed facts, because we get to a position.
Is that the case for which you got permission to appeal?
My lord, no, because this particular point
Well,
had not arisen by
but
then.
then you haven't got permission to run this ground of appeal. I mean, you haven't even formulated it, actually.
Well, my lord, this is responding. This is necessary.
It's now a new appeal.
Well, it's not. It's not a new appeal with respect.
Right, okay.
Responding to the.
I mean, the way that it was put by the respondents is actually there was no error here, so this completely blows this appeal out of the water. That's actually what the respondent's position is. You're saying, no, it doesn't blow it out of the water because we actually can put the case in a different way.
Well, yes, and I'll when I come to deal with the case in the way in which it was put. I would still submit that it was that it was incorrectly dealt with and incorrectly decided on the basis of the way it was put.
So Mr. Eklund, are you submitting that in paragraph 211, the judge states a freestanding conclusion that the premium would have been higher, and then says, and by the way, that happens to be supported by something else? Is that what you're saying?
Well, yes, the important decision which the judge made at that point is that in order for Mr. Penny to have agreed to the non-disclosed facts, agreed to the renewal, taking account of the non-disclosed facts, he would have imposed a higher premium.
Because he would have discovered the error. That's what
Well,
the judge seems to be saying.
Well, let me just take it in stages, if I may.
Yeah, certainly.
One asked the question at that point, higher than what?
Higher than was in fact charged.
Higher than, the answer is higher than, in fact,
Yeah,
what was charged.
yes.
And then one goes on to look at 212. As I have indicated, I reached the conclusion on the balance of probabilities that Mr. Penny would have offered terms for renewal, compelled to that conclusion by a sense of fair play to a long-standing assured and given the less than striking nature of the extra information. However, there were limits to his charity. I conclude that Mr. Penny would have only have underwritten the risk if it was priced at or about the correct price for the risk. Now, at that point, one has to ask the question, what is the risk that he is writing? At that point, she must be referring, and that must mean the disclosed facts and the non-disclosed facts.
Yes.
So that supports in our submission the notion or the proposition that she is confirming in 212 that he would be charging more than what had been charged for the disclosed facts. Because the risk which he was being asked to underwrite, as is referred to in 212, are the disclosed facts plus the non-disclosed facts. That must be, in our submission, that must be right, because they're considering.
Well, I understand that, but I mean, when one reads the judgment, it seems clear, doesn't it, that the judge concluded that no additional premium would be payable by virtue of the undisclosed facts, or attributable to the undisclosed facts.
Well, there's that.
Because otherwise the premium would have been increased by X plus Y, where X is the amount necessary to correct the error, and Y is an additional sum to take account of the now hypothetically disclosed facts.
Well,
but there is no Y.
Well, my lord, but one doesn't get to that point, and it's perhaps a point of causation and effective causation. One doesn't get to the point of even considering the correction of the mistake which he understood without putting into the mix the non-disclosed facts.
No, because non-disclosed facts, of course you're right there, but her process of reasoning was to say that if the non-disclosed facts had been disclosed, the matter would have been escalated to Mr. Penny, and he would have realised something had gone wrong with the pricing. He would have discovered the error.
Yes.
And therefore, the premium would have been increased by X, what I've called X. But she does not say that it would have been increased further by Y.
No, but that's and with respect, that doesn't matter. And the reason that it doesn't matter is because what she is doing is she's finding that there would have been different terms.
But on the basis there was no error, the conclusion, surely asking the hypothetical, is that she would have found there would be no increase.
Well, no, I don't think one can get to that conclusion, because what she says in 211 and 212 is that in order to write the risk on the basis of the non-disclosed facts, he would have required a higher premium.
So you're saying that the judge found that even without an error, there would have been an increased premium?
That's the effect.
No, is that is what you say she found?
I'm saying that
Because without that, you need that finding, don't you?
Well, she did find that there would be an increase.
Yes, but I'm sorry, but my point is that you say that there is a finding that there would have been an increased premium even if there had been no error made in the 2014 calculation of premium.
She does not make that finding.
But don't you need that finding?
No, with respect.
Because you haven't then got a finding that the terms would have been different, have you?
With respect, I don't need that finding because
Right, okay.
211 and 212, she identifies that in order to write the premium with the non-disclosed facts, Mr. Penny would have required in order to write the risk with the non-disclosed facts, Mr. Penny would have required a higher premium.
Irrespective of the error.
Irrespective of the error.
So you say she made that finding?
Yes.
Right. Okay.
What?
Well, if you're right about that, then we don't get into what seems to have taken up most of the skeleton arguments, which is the difference between a causa sine qua non and a causa causans.
I think that's right.
But you would say it's a case of causa causans.
I would.
Your argument was it was a case of causa sine qua non, as I understand it. But you're now saying, well, never mind, it's actually a causa causans because the judge made the necessary finding.
Lord, yes, I think one can put it on the basis of when we come to look at the law and what is required. What the authorities say is that the non-disclosed facts have to be an effective cause.
Yes.
Of the.
Well, I understood before this oral argument began that would be the main area of debate as to what the legal position is. But as I understand it now, we're no longer going to be concerned with that at all because there was no error. So no error for Mr. Penny to discover. So the question becomes, would he have required an increased premium to reflect the additional risk apparent to him if what was in fact not disclosed had been disclosed?
Indeed, on the basis that there was no mistake.
So that would be causa causans, clearly. I don't think there'd be any argument about that. So and if you're right that there's a finding to that effect, then presumably your appeal succeeds, isn't it?
Indeed.
Well, you've got to find the finding.
Well,
Is that right? I mean, I may have got this wrong, but that's how it appears to me at the moment.
And just before you answered, did your answer earlier that the law was that you did have to have an efficient or effective cause mean that you're accepting that the legal test does have to be a causa causans and a causa sine qua non is not sufficient?
I'm accepting that the way in which I put it is that there requires to be an effective the non-disclosure requires to be an effective cause of the insurer entering into the contract on the terms that it did enter it into.
I think
So
it all depends what you mean by effective.
Yes, well, it doesn't have to be the only cause. It doesn't
No,
have to be the
but it has.
doesn't have to be the sole cause. And what I was going to come to in relation to that is that one can actually see in the process of the reasoning of the judgment that there are two causes which are contributing to, or could contribute, and which in fact contribute to the reasoning that there would be an increase in the premium. There's no doubt that the judge has found that there would be an increase in the premium. Now, there are two reasons for that in our submission. One is that Mr. Penny would have required it in order to accommodate the non-disclosed facts. And the second is that the amount of the increase is referable to what was understood to be the mistake in the premium.
Well, those are mutually inconsistent, aren't they? Because the correction of the error is the correction of an error in a rating sheet that pays no attention at all as a relevant input to anything which is the subject matter of the undisclosed facts.
No, but that is...
So it can't be both. It can only be one or the other, can't it?
Well, my lord, the correction of the error comes about because Mr. Penny is considering what to do about renewal when he comes to renewal. And he comes to renewal and he says, well, I've got now a load of other facts to take into account. What am I going to do about it? And on the judge's finding, what he does about it is to increase the premium.
Well, I think the hypothetical needs to take out of it the fact that these things are treated as if they're happening at different times. So I'm simply looking at what Mr. Penny would have done, because he would have been the underwriter rather than Miss Jones at the time when the risk was underwritten. And in terms of rating, what the judge seems to be saying is he would have applied the rating sheet, but he wouldn't have made the mistake which Miss Jones made. So he would have put 6% in, he wouldn't put 1.4% in, and that, the judge says, would have led to a higher premium to that extent. And that is the difference in the premium, which would have been caused by proper disclosure. Not because the disclosure had anything to do with the calculation of the premium, but because it meant that it would actually have been underwritten by Mr. Penny rather than Miss Jones, who wouldn't have made the mistake that she did.
Well, my lord, that's a fair analysis. But the reason that there's a review and the reason that it's being referred to him, and one gets to compare the contract that was entered into with the contract that was subsequently disclosed, is to see whether or not there was a difference or there would have been a difference in those terms. The fact is that the contract was entered into on the basis that there was full disclosure, and a particular premium was imposed and agreed.
Without reference to Miss Jones, on this hypothesis, didn't use as an input anything to do with risk management. So
And without,
whether or not she was or wasn't told anything in relation to the outstanding requirements or special terms would not have made any difference to her.
well, she didn't know about the non-disclosed facts.
No, but it wouldn't have made any difference to her if she was just rating it on the basis of the rating sheet.
Well, we don't know that.
Well, we do know that, don't we? Because we know that that's not a factor which goes into any of the inputs on the rating sheet. The judge has found that there are only three weighting factors. One is the nature of the trade, one is the claims history, and one is the amount of the cover.
Yes, but the reason what we have to compare is what the contract that was entered into was, and what would have happened if this renewal had been postulated on the basis of the non-disclosed facts.
Yeah.
And our submission, the premium would have been higher. That's the finding of the judge is actually making that finding.
And that's paragraph 212, essentially.
That's paragraph 211 and 212. And what she does is to compute. She then says, well, how much would it have been? She says it would have been enough. In effect, she says that it would have been that which related to Zurich's earlier errors. And that brings about in itself a different contract from the one that was agreed. And the reason that there would have been an increase in the premium is not only because of the earlier errors. Those would not have been corrected by themselves. The only reason that anybody would be looking at it would be because there is an additional risk to be taken into account, namely the non-disclosed facts.
It's not a question of two stages at which one person looks at it and then another person would have been looking at it. The single question on the judge's findings is what premium would Mr. Penny have charged if he'd been underwriting it at renewal?
Yes, on them.
And one talks about correcting a mistake, but in a sense it's not making the mistake, which in fact was made by Miss Jones, if he'd done it on the basis of the rating schedule.
Yes, but that's not looking at the contract which was actually made and comparing it with the contract which would be subsequently made on the basis of the non-disclosed fact.
It wouldn't. The contract wouldn't have been made subsequently. It would have been made at the same time. It happens it would have been made by a different person. The question is, what terms would that person have imposed? And he would not have made the mistake, which on the judge's findings, Miss Jones made, of putting the wrong figure in at 2.25%. Isn't that the analysis?
Well, at that point, that is the analysis. That one can see that that's the analysis of the process of looking at the computation of the premium. But then one has to take into account that that was mistaken. That the judge, there was no error. There was no error in the actual computation of the premium. There may have been a difference in the reasoning, but there was actually no error in the computation of the premium. So that is something which the judge has not taken into account. So when one looks at it and takes into account that there was no error in the computation of the premium, one is left with looking at and considering paragraph 211 and 212, by which where the judge found that Mr. Penny, with some clarity, if I may say so, would have imposed a higher premium and would have priced it at or about the correct price for the risk. Now, the correct price, if there had been no error and the correct price for the risk took into account the non-disclosed facts, it seems to follow in our submission that the correct price for the risk, including the non-disclosed facts, would have to be higher.
That rather ignores the rating process, which was the rating process within Zurich, and presumably Mr. Penny's just as much as those of his juniors, including Miss Jones, which was that a rating system was used which only had inputs in relation to the nature of the business, the amount of cover and the claims history, and did not have as an input in deciding the amount of premium any attitude to risk management or any facts about risk management.
Well, my lord, it's...
I mean, that's what when you use the expression the correct price, so far as Zurich were concerned, the correct price was identified in the method I've just identified,
Well,
wasn't it?
my lord, I'm not... That cannot be correct in relation, if one takes into account 211, where the judge says that he would have imposed a higher premium.
I mean, there's a danger in picking one sentence out of one paragraph and not looking at all the paragraphs together. We've got to focus on paragraph 214 as well.
I entirely agree with that.
We can't just chop it up. I mean, I can understand why you're doing that, but I'm afraid it's not the correct approach.
Well, I understand that observation, but that's what I'm trying to do.
I appreciate it.
To look at the whole
But
process.
we have your point.
have
You
your
say that
process
if you
of
stop at 211, this leads to the conclusion that there would have been an increased premium to reflect what you say is the increased risk.
Yes.
We understand that that's the way you read 211, and I can understand why you read 211 in that way, read on its own, but we invite you now to give us your submissions on how we should read it in the context of what the judge later says.
May I just ask a question first, please? Mr. Eckland, was there any evidence before the judge about whether or not an underwriter in Zurich had a discretion to depart from the rating process or not? Because that's rather important in the light of the submissions you're now making.
I don't recall, but I suspect Mr. Penny, as the senior underwriter, would have had a discretion to do so.
But in a sense, my lady's question points up a central factor here, which is that your case was an all or nothing case. And I think probably your case was Mr. Penny had a discretion whether to accept the risk at all. And your case was he would not have accepted the risk, would not have written the policy at all. That would have been the end of it. You didn't go on to explore, did you? Well, would he have imposed different terms as a sort of an alternative case? So you never got to addressing the point which my lady rightly says would have to have been addressed if that was your alternative, if you had had that alternative case.
That is so. Mr. Penny himself put the case on the basis that he would not have written the risk.
Yes.
The judge, of course, looked at that evidence in the context of the Morford allegations and the way in which it had been put and not developed. We had pleaded from the outset and included in our both skeletons that Zurich would either not have written the risk or would not have written it on those terms. But I accept that it was not at the forefront, and the judge found, and I don't shy away from that, it was not at the forefront of our argument.
Or was it part of your argument at all?
Well, it was part of our argument, but it wasn't at the forefront of our argument.
Right, it was part of your argument.
But you didn't lead evidence, did you, either on the point my lady has raised, or on whether in fact there would have been an increased premium?
No, we didn't lead evidence on that, no.
So how could the judge make a finding on this?
Well, the judge The judge has made the finding that she has by rejecting or not accepting Mr. Penny's evidence that he would have rejected the risk
Oh
outright.
no, absolutely. But she's then gone on to say, well, I can see, however, that there was this error which Mr. Penny would have discovered, and he would have been the underwriter. So the terms would have been different, but they're not actually terms that were different because of the increased risk.
Yes, so she's gone on.
There's an out.
She has gone on to say that he would have required an additional premium once he knew of the non-disclosed facts. There was a limit to his charity,
Yeah.
and then by way of calculation, that he would have increased the premium, but by reference to the mistake which had previously been made.
Yes.
So we derive from that, and I think it's right to say that the premium would have been different than that which had been imposed, and that there was an increase, and the only reason for the looking at it and considering the increased premium was because he would be taking into account and looking at the fact that there were additional risks. So he may have rated it in a different way to the way in which Miss Jones had rated it, but the reason that he was doing that was because there were different risks which he was being asked to take into account, namely the non-disclosed risks. So that 214
Yeah.
can be seen quite properly as the calculation of the amount of the increase that he would have imposed to take account of the non-disclosed risks.
Well, that's not quite what 214 is addressing. 214 is where she concludes that the non-disclosure would not have been causative of the different terms. But that in turn is based on her understanding as to what Zurich accepted. We see that in the last two sentences of 214. So she understood your case to be that the only change, well, she says it, which Mr. Penny would have made, was one that didn't relate to the non-disclosed fact, but which related to Zurich's earlier error.
Yes, well, my lord, there was no earlier error. That's
Well, we now know there was no
we now
error,
know
but
there's
she
no-
understood at the time that there was, and I think you didn't dispute that, did you?
the way in which it came about
Oh,
was through cross-examination by my learned friend
yes,
of Mr. Penny,
right.
a prolonged period of cross-examination, and which concluded. I don't want to take you through it all, but there's a reference.
That's how the error came out.
That's how the error came out. It's concluded.
So having had that evidence, she concluded, well, actually, there would have been a change. In fact, there would have been a change to the premium, but unrelated to the non-disclosed matters, except on a sort of causa sine qua non basis.
Well, what was put to Mr. Penny was that there'd been a mistake in the calculation of the premium.
Right.
And so that led the judge to the finding that she's made at 214, that the mistake would have been corrected. We now know there was not a mistake.
Right.
That's what's accepted.
I'm sorry to slow you up. Can I just see if I've understood which the relevant passage in the cross-examination is? Is it what we've got at page 141 of the supplementary bundle? When Mr. Elkington had been cross-examining initially on Mr. Penny's report in March after
Yes.
the fire, and then at 283,
It starts at 283.
starts at 283,
Goes on to
and That's it being asked about the 2013 rating sheet. And the question at line 11, it's been rated as a waste risk. That's the answer. That's the 6%. That's the start rate, yes. If it wasn't a waste risk, that 6% would be lower. Yes, be closer to 2% for a standard contractor's plant. So the upshot was that Niramax was paying the premium that Zurich thought was appropriate for a waste risk. So that's the 2013 rating sheet. Then goes on the following page, bottom left, to the 2014 document. You see the handler top left says Michael Smith. So this is given by reference to the assumption, which the judge held was wrong, that it was Mr. Smith who had done this exercise, not Miss Jones. About 2 inches up from the bottom, it says rationale for underwriting judgment factor loading for trade. Yes, that's the bit you've now spotted you previously missed, which showed that it was being increased because of it being a waste risk. Yes, and I'm not sure why he's done that, because at this point he could have picked waste as a trade. He's actually picked contractor's plant for some reason. I don't know why. Question, there are two different ways of taking account of it, but he's adopted one way. Yes, the correct way of doing it is to use the waste recycling trade. So he's correctly identified it's a waste risk, but he's not performed this calculation correctly. Just pausing there. So as I understand it, what Mr. Penny is saying is that the error in the 2014 rating sheet is that it should have taken into account that it was a waste risk in that line near the top with a 6% rather than the 2.25%, which Ms. Jones in fact used, but that you shouldn't have had the uplift for 1.4% in the rationale for underwriters' judgment. And then you finally get the answer, correct, yes, which is why his premium is lower than the previous one.
Yes.
And the premium isn't in fact in the end lower than the previous one, but one of the figures on the way is lower because you get to a figure of about 18,000 rather than a figure of something near
23.
Well, no, nearer 48,000 if you apply 6%.
Well, and then it goes on and concludes at line 19. Question under the first control exception, you conclude by saying effectively an authority breach because it did not establish that the risk trade was within authority. I think you would tweak that now because you would accept it was established that it was a waste risk. Yes, that Michael Smith did not do his premium calculation correctly.
Yes.
He did not, no. And that's the mistake. I think that's the judge has picked up, which we now know is no longer a mistake.
Yeah, thank you. That's the evidential foundation.
That's the evidential foundation.
Thank you. And whilst I've interrupted you, do you think either you or Junior at some stage, not necessarily now, could give me the reference in your closing submissions to where you say you did maintain as an alternative that the renewal would have taken place on different terms?
Yes.
Don't worry if you haven't got it to hand. I'd just like to chase it down in you.
So can I leave that there for the moment and just look at the law very quickly?
Yes.
And for that purpose, I'd like
What's the problem? We're assuming that there would have been a higher premium because of disclosure of what was in fact not disclosed.
That's the proposition. There was no mistake.
No, I understand. You're saying, I'm just wondering, I mean, that's probably a well-established principle, isn't it? I mean, I'm just wondering what we're going to the law for. Really?
Well, I was not going to go there extensively.
No, all right.
Because
But I
of
mean,
that.
but
And I was hoping not to open any of the authority buttons because you'll see we've set it out pretty
yes, you have very
substantially
well.
in our
So
skeleton.
the point here is that but for the non-disclosure, I mean, not but for, but
No.
not but for the non-disclosure exactly, but I was trying to do it in shorthand, but there would have been a different contract. The terms of the policy would have been different because the insurer would have increased the premium
Yes,
because of the non-disclosed matters.
yes,
So
if
that
that's
the non-disclosure was an effective cause
indeed,
of the premium being lower than it otherwise would have been.
yes.
Doubt whether we need much authority to establish that. But
No,
What I pressed you on earlier was whether if you change the factual hypothesis and the judge's findings are to be interpreted as taken at their face value, namely the only increase in the rating, or the only difference between what Mr. Penny would have charged in the case of disclosure from what Miss Jones in fact charged was whatever difference would be created by correcting those errors we've just been looking at in the rating sheet. If that's the factual hypothesis, do you still say as a matter of law that you satisfy the causation test?
yes, I do. And the reason that I say that is because the reason for the correction is brought about by taking account of the non-disclosed facts. What the correction does is, by way of calculation, amend the premium or change the premium to take account of the non-disclosed facts. Now, the way the judge presents it, or the way the judge puts it, is that the premium is increased by reference to the correction of the mistake. But that doesn't take away the fact that there is an increase brought about by the non-disclosed facts becoming known.
Well, that's the difficulty I have in your assertion that it was brought about by taking account of the undisclosed facts. I quite understand the point you've been on for most of the morning.
Yeah.
My fault as much as anybody's that it's taken you that long. I quite understand your point about paragraph 211 and the finding being independent of correction of the error. But if you're wrong about that, and one just takes the judge's findings, then I don't see why you say that the reason for the correction is brought about by taking account of the undisclosed facts. What one's looking at is, what would Mr. Penny have charged had he been told the undisclosed facts? And the answer on this hypothesis of the judge's findings is he would only have charged more because Miss Jones made a mistake, not because of anything to do with the undisclosed facts. Now,
Yes.
if that's the analysis, do you still say that you get through what is the legal test?
Well,
Or is that not simply a but-for test of causation?
Well, my lord, that is to separate out completely the adjustment of the premium, the reason for the adjustment of the premium.
It is, but the reason I'm pressing you is because what you said you were going to embark upon on the law on the basis of what you say the relevant findings are, I doubt is controversial. What I really want to know is, are you going to suggest that the law says that a satisfaction of a but-for test is sufficient?
No, as I said earlier, I submit that what one has got to do is to identify an effective cause. But one can identify here that the increase in the non-disclosed facts are an effective cause of the increase in the premium. And the increase in the premium is calculated, as we see, by reference to the correction of the mistaken premium. Now, that mistaken premium now turns out to be not a mistaken premium. So it would be rather odd if Mr. Penny...
I understand that. I mean, the reason I ask is that there's quite a good deal in your skeleton argument saying that once the judge had found that the premium would have been different. That's it. That's enough.
Yes.
Doesn't matter what the reasons were for the premium being different. But you no longer maintain that.
Well, I am in effect maintaining that because the underlying reason for the increase in the premium is the non-disclosed facts. That's
So that's not. Of course, that's if that's right, then the reason for the increase in premium is matters and is in play. But there's a good deal in your skeleton, which is that once the judge had found that the terms would have been different, she shouldn't have gone on to consider what the additional premium would have been and why.
well,
But
my lord,
if you accept, do you, that it is a relevant inquiry because it needs to be an efficient cause to inquire why the additional terms would be higher and to establish that at least a cause, not the sole cause, but a cause of the terms being different would have been disclosure of facts which were undisclosed.
yes, well, I certainly put it on that basis that a cause was the non-disclosure of the facts, and in fact, it's not inappropriate to look at it in this way, that there are in fact two causes going on here. One is the non-disclosure of the facts, and the other is the correction of the premium. And they're not independent of each other. So that the non-disclosure of the facts remains an effective cause for there being an increase in the premium.
I'm sorry, I'm having the gravest difficulty with this in the light of what the judge says in 214. I mean, because she has proceeded on the basis that there was a mistake. Mr. Penny would have noticed it, and that would have led to an increased premium, correcting the mistake. But there would have been no increase which was related to the non-disclosed facts. That's what she says.
Well, my lord,
Now you're saying, well, there wasn't an error, so frankly, the bulk of the legal argument in the skeletons is really beside the point now, because the point just doesn't arise on the facts. But you're trying to get out of the judgment a different finding.
well, I can't.
That's the difficulty that I'm seeing.
Well, my lord, I can't get out of the judgment with a different finding that's not there. I understand that.
Yes.
I understand that. But our analysis is that having concluded that a higher premium would be charged, and having concluded that the risk would only be written at or about the right price for the risk, and now that we know that that there was no mistake in the premium that had been calculated, that calculation could only have related to the disclosed fact. Could not have related to the non-disclosed facts. And so once one takes into account that there is a mistake in the judge's reasoning, it's our submission that she was wrong, or it would be wrong, to find that there was no increase, or there would have been no increase to the premium.
You're taking out, as it were, headline is there would have been an increased premium. The substrata of that, the reasoning for that is it would have corrected an error. If you take that out, how can you leave the headline?
Well, my lord, perhaps I'm not making myself clear. But if one takes out of the fact that there is no mistake,
Yes.
then you're left with the insurers apparently just agreeing to write a risk which they had no knowledge of on the same terms that they would have written the risk.
Yes, because there was no evidence to the contrary. I mean, having decided they would have written the policy, which is what she did decide, there was no basis, but for the error point, because that came out in the evidence, there was no basis in the evidence, was there, to conclude that the terms would have been different.
Well, there's no evidence to that effect. I accept that.
And it would not be a very surprising conclusion that it would have made no difference, given the way, as the judge found, premium was calculated, not only by Zurich, but in this industry. We've got a paragraph 25, the evidence that this was a type of insurance which was commoditised, streamlined as a cost-saving exercise. There was no proposal form. There were only 3 inputs into the calculation of a premium: sums insured, trade, and claims experience. This was apparently a standard approach across the industry. The experts did not cavil at it. And then we've got the passage of paragraphs 99 and 100, which we've seen that indeed was Zurich's practice. So the matters to which the undisclosed facts went did not, either as a matter of Zurich's practice or practice in the industry, constitute an input which would be taken into account in deciding how much premium to charge. So it's not very surprising, is it, that if you leave aside an error in the way those inputs were put in, the judge's conclusion would be it would have made no difference.
Well, I respectfully disagree.
Yeah, but why?
Well, I disagree because of the effect of the expert evidence is that this was a grave. I mean, Mr. McElduff, the Niramax's expert evidence was that this was a grave concern. This would have been a grave concern that the non-compliance with the risk requirements by Niramax of other insurers would have been a grave concern.
For a prudent insurer.
For a prudent insurer. And indeed, Mr. Coates's evidence, that the judge accepted this as paragraph 158, that it went to the heart of the management of the risk. And when those factors are taken into account, then one would be very surprised if there was not to be an increased premium. And indeed, the judge has found that there would be an increased premium.
But I speak for myself, I wouldn't, given the judge's findings about how people calculated premium in this market, I don't think it would be surprising that there was no increased premium. Yes, of course, it was material to a prudent insurer in deciding whether to write the risk at all. And in this market, insurers were increasingly reluctant to do so, and so on. But if the standard practice, once you've decided to write it, is not to take that into account in rating the premium, why should one assume that any prudent insurer, or more particularly what matters for this case, Zurich, would have charged a higher premium?
Well, because of the gravity of the gravity of the situation, and it would be very surprising if they'd been told that the property insurers had increased the premium by had increased the deductible to 250,000, I think, from 5,000, and imposed a 35% self-insured provision. It would be very surprising if subsequent insurers just ignored that.
But that's a different market. That's the property market.
I appreciate
You've got buildings insurance, in which, as one's seen from this case, it'll often be subject to survey, and there'll be surveys, and there'll be impositions of requirements.
I appreciate it.
In this market, there aren't any surveys. There's no questionnaire. There's no focus at all on attitude to risk management.
And also, isn't the gravamen of your point reflected in the considerations the judge mentions in paragraph 210, where she's dealing with the effect that disclosure would have had, and she's really saying there that Mr. Penny would have thought long and hard about whether to renew, and on balance he'd have decided to renew. So it's not as though those factors weren't taken into account by the judge; they were.
No, I entirely follow that. That's part of my point. But he goes on, as we looked at perhaps too often now, 211, that she would have required, that he would have required an increased premium.
All right. Well, okay. How do you deal with paragraph 214? Which ends with the non-disclosure would not have been causative of the different terms, because there wouldn't have been an increase referable to the non-disclosure.
Well, the first point is that it's wrong. Okay. The second point is that the non-disclosure remained an effective cause of bringing about the increase in the premium. There was an increase in the premium, or there would have been. The third point is that it is mistaken, the conclusion is mistaken because it's based on a mistake.
The mistake being?
The mistake being that there had been an error in the calculation of the premium.
Right, okay. Right. Well, yes, okay. Right.
And the fourth is that the non-disclosure, it's the non-disclosure which brings about the review of the premium, which gives rise, which satisfies the requirement that Mr. Penny would have required a higher premium.
Can you just repeat that?
It's not a review. It doesn't happen chronologically in two stages. The hypothesis one's looking at is what would Mr. Penny have done at the time? What premium would he have charged?
Yes, well, the premium that he would have charged would have been one that was higher than had been charged.
When you say it was your fourth point, it's the non-disclosure which brings about the review. What do you mean by that?
Well, the underwriting of the policy would have been referred to him because of the non-disclosure, because of the terms that are there in play. I beg your pardon, because of the non-disclosed facts which are in play and the seriousness of them, which would have brought about the higher premium that he would have wanted. One can encapsulate it in this way, that I won't use the word review, but his assessment would have been that a higher premium was required, the calculation of which was by reference to the mistaken assessment of the premium which had been undertaken. That's what the judge is effectively saying. The calculation of the higher premium would be by reference to the undercharged premium.
Why would it only have been that?
Well, I would agree. Why would it have only been that? That's what the judge has found.
Yes.
That's what the judge has found by way of calculation.
Well, now, I thought you might have going to say something about the penultimate sentence of 214, where she records that Zurich accepted that the only change which Mr. Penny would have made to the terms is not one which was related to the non-disclosed fact, but one which related to Zurich's earlier errors. Yes. But, I mean, you actually say in your skeleton that was wrong, that Zurich didn't accept that.
Well, Zurich has never formally accepted that.
But
I think that's...
It's quite an important, I mean, this is an important statement by the judge here.
Oh.
Because, isn't it?
Zurich has never formally accepted that.
But did you challenge, when her judgment was circulated in draft before hand down, did you challenge that? So
No.
look, no.
I think that derives from the cross-examination of Mr. Penny.
But it may also derive from the fact that it simply wasn't part of your case, that the terms would have been different, because your case was there wouldn't have been a policy.
Well, I don't think it derives from that. I don't think it derives
No, it would be fair enough. It probably doesn't quite, but anyway. Well,
sorry. I'm so sorry. When you say Zurich never formally accepted that, why do you use the word formally?
Well, because I think Mr. Penny may have accepted it in evidence.
Oh, I see. Well,
and the evidence you're referring to was the passage we looked at earlier.
Yes, and earlier, and I mean there's a long cross-examination by Mr. Elkington and Mr. Penny, which culminates in that passage that we looked at earlier, which he accepts that there was a mistake in the premium calculation.
Could you just give me the, again, not necessarily now, the page references, so I can look at that.
I can do.
Thank you.
But I mean, if I'm sorry, I don't know that. I mean, I think I'm not sure in the bit that you showed us a few minutes ago that there was a sort of clear acceptance by Mr. Penny of what is recorded by the judge there. But if he said it elsewhere, that's quite significant.
Yeah.
And he was the underwriter.
He was the underwriter, and all I'm saying is that there was quite a long passage of cross-examination.
I mean, do you say that he did accept that in cross-examination?
Well, I don't think he accepted that.
No, all right.
Cross-examination.
So, all right. Well, that's what I was sort of getting
No,
at,
he
really.
accepted. He
All
accepted
right.
that there was a mistake.
Well,
So is that sentence an inference drawn from the judge? Sorry, drawn by the judge from what Mr. Penny said in cross-examination.
That's my understanding of it.
Right.
It is in any event, isn't it, a finding by the judge, because she says, in my view, correctly.
It is.
yeah. Well, now, Mr. Eklund, we've spent quite rightly quite a long time on these few paragraphs of this judgment. I mean, is there anything more you want to say about these paragraphs?
Let me just check. Can I just check behind?
Of course, yes.
Well, I think I've covered everything.
Very well. Well, thank you very much. Thank you. Yes, Mr. Elton. Sorry, forgive me.
Sorry,
yes,
I'm
of
so
course.
sorry. Could I just ask you to go back to the rating sheets and look at the one for 2014, which is in the supplementary bundle at page 115.
We have A3 versions if it would help, because I know some copies are very difficult to look at.
I would be very happy to see a larger version.
I've got an even larger version.
Oh, well
of that.
done.
And in fact,
Is that what we've got?
no,
ours
my clerk did this.
Don't worry, well, we've got some
But
coming.
we've got
I
A3
think.
versions in our bundles.
Oh, we've got A3.
I didn't know some people are working electronically.
Oh, I see. Now I've got A3. Yes,
We've
I've
got A3 in the bundles, but
Some were very
This
dark
is clearer,
copies.
I
I don't know if those will be exactly.
Thank you. I've got a wonderful sized one here.
and I just wanted really the help
I
of
think we've got them. Don't worry. Thank you.
both of you, if I can just put my hands on my
Which page was it, Marie?
115, which is the 2014 rating schedule. And I just wanted to understand how this works, if you're able to help me, or send me to the relevant bits in the evidence that will help me. We've got a box about a third of the way down saying owned plant and machinery select cover requirement, which has the 812,000 figure in it.
Yes.
And that's the one to which 2.25% has been applied. And we can see at the end of that box that gives an 18,270 figure. Then you've got a box in relation to hired in plant and machinery select cover requirement, and you've got figures in there which involve actually only a very small addition of 4.5% of the 3,000, an extra £135 of premium, And then in the next box but one, there seems to be a 5% discount applied for plant volume, because against the plant volume line we get 0.95, a figure of 17484.75, which is in fact 95% of the sum of 18270 and 135. So we end up with a figure there of 17484.75.
I don't see that figure. Maybe I'm looking at the wrong page.
So about halfway down the page, there's a figure for plant. There's a box headed plant overall. Do you see that one?
So what is the page number in the bundle again, if I may?
115.
Yes. It's got 2644.
2644.
Yeah.
And about halfway down on the right hand side, there's a figure of 17484.75.
Yes, I see that.
And that one can see from the maths is calculated as being 95%
Yes.
of the sum of 135 and 18270, which we've got above. And in the first box that's populated essentially, which is headed own plant and machinery select cover requirement, that's where you've got the amount of cover of 812,000 and the 2.250% figure applied to it to get your 18270. And that's the point at which, in Mr. Penny's evidence, which we've looked at, he said that's an error. That's the general figure, and it should have been 6% for the waste product grade. So we end up, after that exercise has been done, with a figure of 17484.75. If we just pause there and go to the bottom of the page, there is, above the bottom two boxes, a box which says actual premium agreed by underwriter, £23,714.40. You following where I am now?
Yes, yes, yes.
And that is what was in fact charged.
That's what was charged.
But there are above that figures, a technical price, a target price, and a walk away price. And if we go to the first of those, it's in the box marked pre-adjustment technical price, and that has a figure of 15985. Is it 61?
Yes.
And then there's also a target price and a walk-away price, which, if I've understood it correctly, have been calculated in the first case as simply 5% above the technical price as the target, and in the second case as 1% below the figure as a walk-away price, which presumably is meant to reflect the price below which they won't write the risk. Then there's another box saying renewal bonus adjustment, which doesn't actually make any adjustment to the figures. And then we get the underwriting judgment box, which was where Ms. Jones has taken account of loading for the waste cycle trade of a 1.4 figure. And 1.4 has then been applied below that to the technical price, becomes 22,379.86. 5% above is 23,498. 1% below is 21,455. And that appears to be what is derived from the technical price. And then, as we've seen, actually the premium isn't any of those, but it's a bit more than the target price, and it's certainly above the walkaway price.
Yes.
And we know it is in fact 20% above the previous years. Now, what I am interested in, if you can help me, is what is the relationship, because I couldn't work this out from the figures at all, between the 17,484.75 figure, which one has got from applying the 2.25% halfway down on the right hand side, and the pre-adjustment technical price, which is what seems to feed into the ultimate figures which the underwriter is going to decide are the target or not going to be enough. Don't worry if you can't help me on your feet, but I'm interested in that, and I'd obviously be interested if Mr. Elkington can help me on that as well.
Well, I think as I stand here, I can't really help you with that.
Right, thank you.
Well, Mr. Hickman, thank you very much indeed. Yes, Mr. Elkington.
Good morning. Can I first apologise that we're rudely swigging and uncouthly swigging from
Don't worry about that. That's the rule at the moment.
That's the rule. I say it not only to apologise, but also because there's a danger that my mother's watching this through the YouTube live link, and I want to avoid a scolding when this finishes for not using a glass. But it's because of the regulations. I've really got to rip up most of my notes for this hearing because this hearing has not proceeded as I expected. You'd have seen that we put in a respondent's notice saying that the judge was in fact mistaken to think that there was a premium calculation error which would have led to a higher premium had the premium been calculated properly. One might have thought if that was common ground, it would have been mentioned as common ground in the replacement skeleton we had. We'd no idea what Zurich's case on that was, but we now understand that that's actually accepted. Because my submission was going to be that I had 3 grounds to cover, limb 1 of the appeal, and I'll cross appeal, and if you're with me on either of those, either Corzan's point, or the factual cross appeal point, then we succeed. And then responding to the second limb of the appeal, which is that the judge should have found that an even higher premium would have been charged. I'm not sure if that limb's still pursued. But as it is, because that second, our cross appeal has effectively been conceded, the shape of the appeal is very different. I think what I'd like to do is make some very brief introductory remarks, which just to set the context, and then dive into the way the premium was calculated, touching on what we've just been looking at, and the judge's findings, and then go and look at the judgment, and then see what, if anything, more I need to cover after that. Just by way of the introductory remarks, you know this relates to mobile plants. The significance of that is it can be all over the country. It's not fixed plant at a particular premises, and that's why the underwriting of this is different to the underwriting of buildings insurance, which are fixed. The plant could be anywhere.
But in fact, is it moved around? Or is it in fact spend all or most of its time in the 2
Niramax
sites?
had more than one site. So,
Washington and Hartlepool.
So some of it was used in more than one
But it's
site.
not like sort of builders' equipment which could travel the country.
No. This particular type of industry, there's less movement in fixed plant than, as you say, with a builder, where it might take cranes and grabs all over the country. Sure. But because of the nature of the insurance, as you've seen it's commoditised insurance. It's rather like domestic car insurance in a sort of commercial context. And you've seen, you've already referred to the relevant passages in the judgment, paragraphs 25 and 99, where the judge says it's commoditised, which no one criticises. Competition, keep the premiums down. The underwriting is limited with just the 3 inputs. Second introductory point, this claim arises out of a fire in December 2015, which was entirely accidental. Niramax had bad luck in 2 ways. The judge refers to this in paragraph 1 of her judgment. Firstly, a hydraulic hose in a grab failed, which released oil onto a hot pipe, which caused a fire. That's the first unfortunate fact. Secondly was that although the staff thought that they'd put the fire out, on that night there were particularly strong winds, which led to embers which hadn't been put out, blowing into another part of the site and starting a fire. And what was particularly unfortunate for Niramax is that burnt down the new shed with the new Eggersman plant in, causing a loss of £4 million, plant which had only just been commissioned. And as you know, the claim for that part of its loss has failed. And so what they were left with is the claim for the movable plant, which was destroyed, for which their claim succeeded. And luckily, Niramax had paid for insurance for damage to that plant, and it had had cover since as long ago as 2006. And so it made a claim on its policy. And a striking feature of this case is that for 2 years nearly, Zurich neither paid the claim nor avoided the policy. 2 years. And so proceedings had to be issued, which prompted the inevitable avoidance. And at that point, Zurich relied on numerous bases of avoidance, all of which were either abandoned or failed at trial. And it was during the course of the litigation that there were numerous amendments to its defence. By the time of the trial, we were on the re-amended defence and counterclaim. And one of the amendments that was introduced in 2019, so some 2 years after proceedings issued, was the one that ultimately succeeded at trial, which had been the non-disclosures in relation to the property insurance. And prior to that, Zurich had never shown any interest in Niramax's property insurance. It might have had no property insurance at all. Had there been no property insurance, there wouldn't have been a complaint about that. We wouldn't be here. And there's never been any suggestion that the non-disclosed facts relating to the property insurance were causative of the fire. They're entirely separate. So it's a classic case of an insurer, after a loss, looking for a ground on which it might avoid paying a claim under a policy for reasons which had no causative effect. And the law is that sometimes that succeeds, and sometimes it doesn't, however unattractive it may be. And from a financial point of view, as I've said, Zurich was largely successful. It escaped paying the 4.3 million for the Eggersman plant, and the question for this court is whether it can also escape liability for the 500,000 which the judge said it had to pay for the mobile plant. Now, Zurich's case at trial was that had it received full disclosure from Niramax, it wouldn't have renewed the policy in 2014. The right or no right distinction that the judge referred to. And it adduced no evidence that it would have renewed the policy, but only on different terms. Now, it would have been very easy, had it been true, for Mr. Penny to come along and say, well, yes, I would have renewed the policy. Well, I wouldn't have renewed the policy, but if I'm wrong about that, I certainly only renewed it on different terms, for example, requiring that all the risk improvements that were outstanding to be complied within 30 days, or I would have charged a higher premium. But he didn't give any such evidence. It never said that had it received full disclosure, it would have charged a higher premium. So Zurich seeking to escape liability now for the £500,000 which it's been required to pay, on the ground that it would have charged a higher premium, despite it never having adduced any evidence to that effect, and despite advancing no argument to that effect. And what it's seeking to do is piggyback on a finding made by the judge, which she expressly says is for completeness only, because it sets the context for the next bit of her judgment relating to the Eggersman plant. It's seeking to piggyback on that finding to say that there's a basis for avoiding the policy. So, even after the trial, Zurich is continuing its determined efforts to find a way to avoid liability under the policy, advancing a new argument it's never previously advanced before or during the trial. And my Lord Justice Popplewell inquired about the closing. Could I just take you to the relevant bits of the closing submissions of Zurich, which are in the supplementary bundle at they start at page 42. Behind tab 5 if you're blessed with tabs. So it's a lengthy document, some 64 pages, and the relevant section on inducement starts at page 66 of the supplemental bundle. In this case, it's paragraph 44. In this case, analysis of the necessarily hypothetical question of what would have happened if the material facts alleged by Zurich had been disclosed to Zurich in December 14 at the renewal of the policy on September 15, when the Eggersman was added to the policy, is a two-stage process. Paragraph 45, the first stage is to ask who would ultimately have made the underwriting decisions. We can skip on to 46. The second stage is to ask what Mr. Penny would have done at renewal in December 2014 and in September 2015. And at the bottom of the page, it starts with the stage 1 and deals with renewal in 2014. And as you know, the judge accepted Zurich's case that the matter would have been referred by Miss Jones to Mr. Trinham on to Mr. Penny. And there's no challenge to any of that. And then stage 2 is picked up at paragraph 67 on page 74 of the bundle. Mr. Penny in 2014 and 2015. Mr. Penny's evidence is clear that if he'd been asked in December 14 at renewal of the policy or in September 15 when the examen was added to the policy, what he would have done if he'd been made aware of the failure to comply with the risk improvements and special terms imposed by Millennium as a result. And those matters, whether individual taken, would have caused him to A, decline to offer to renew the policy in December, and you know the judge rejected that in paragraphs 201 and 208 of her judgment. B, decline to agree to add the Eggsman plant in 2015. The judge accepted that, paragraph 216 of her judgment. And C, cancel the policy in September 2015. The judge rejected that in paragraphs 225 and 226. No fallback case advanced that there would have been, he would have done something on different terms. The passing reference that the judge referred to is in paragraph 78 on page 80 of this bundle. Where's the... So it's little b. Zurich would not have offered insurance to Niramax on the same terms or at all in 2014 and would not have added Eggsman in 2015. So what was being said there, that again is consistent with the would not have renewed in that wouldn't have offered insurance on the same or any terms. What it's not saying is that Zurich would have renewed on different terms. And there's absolutely no mention anywhere in this document about Zurich charging a higher premium to reflect the undisclosed risks. So the key underwriter on whose evidence Zurich relied was Mr. Penny. He gave both a witness statement and a supplemental witness statement, which you have in the supplementary bundle, 34 pages of written evidence, and he gave oral evidence running to 200 pages of transcripts, which you also have. Nowhere in his written or oral evidence did he make any suggestion that if he was wrong about renewing the policy, that he wouldn't have done so, wouldn't have offered terms, then he would have renewed, but on different terms, such as a higher premium. So had the judge reached such a conclusion, I would have been standing in Mr. Excellent's shoes and saying, well, where was the evidential basis for the judge to conclude that a higher premium would have been charged when there was no evidence to that effect and no argument to that effect? I would have had a good appeal on the basis that that was an evidence, an appeal for which there was a factual finding for which there was no evidence. So the suggestion that the judge can be criticised for having failed to reach such a finding, which I think is the second limb of Zurich's appeal, if it's pursued, is entirely unfair. What has given Zurich, or Zurich thought it had been given a foothold to appeal on, was the judge's finding, which she said for completeness, as to the fact that there would have been a change in premium. And if I can just run through, if I can just summarise it this way and see to what extent it would help to run through the documents. You know that in 2013 a particular premium was charged, and that included a 10% uplift because there was a general understanding in the industry that waste risks were liable to have fires.
A 10% uplift on the previous year.
Previous year, yes. And that's at, you see that at paragraph 204 of her judgment.
I'd read that as Zurich's attitude to fixed plant waste risks, which wasn't this policy. But that's what had in fact happened on this policy in 2013.
I should check that was my recollection, but I should check that. We haven't got the 2012 premium figures here to see if that's a 10% increase in the way that was then a 20% increase. But there was what is common ground is that there was an awareness of the problems that were with the waste industry.
But if that is right, does it follow that in 2013 the premium wasn't in fact fixed by applying the 2013 rating sheet?
No, 13 we can look at 13 to see how, if we look at the 13 rating sheet, which is in 107, I'm just getting looking at my cross-reference relating to the 10%. Yes, it would. It's sorry to take you to a different reference. It's in the same supplementary bundle still, at page 196. The transcript page 503, line 10. We're writing renewal at 19,762 plus IPT, which is a 10% increase on the expiring premium of 17,965. This is a standard increase for this trade. I ask again, this trade is what waste? Yes.
So it's not calculated in accordance with the schedule, but it is, as it happens, within the range between the target price and the walkaway price.
Yes.
That was in fact calculated in the
Yes.
2013 schedule. Yes, all right. Thank you.
If we look at page 107 together, that is the rating sheet for 2013,
Yes.
and you have the 2/3 of the way up the 812 and the 6%, and then the below that the hired-in plant, and the 6% is the right figure for the waste risk we know. Then you have the hired-in plant with the hired-in plant charges, and you have 4.5% of that, which gives you the £135 figure. And just for your reference, the sum insured there, any one occurrence, is 50,000. That went up to 150,000 in the next year, but that doesn't make a difference to the premium because, as was explained in the evidence, the premium is based on the hard charge of 3,000, and that didn't change. And because it's 68,000, so 6%, you have a much bigger figure of 48,000 and then 135, which rather begs the question, well, why is it that the target premiums are so much less than that? They're down in the high teens or 20,000. And I did ask about that, and the evidence was in effect that there are, you put in the figure and the computer gives you the number. The witnesses weren't able to explain, didn't know where the figures go after you have the straightforward application of 6% and 4.5%. What happens after that?
But the evidence was that the figure you've got for your pre-adjustment technical price was the result of the input.
Yes.
In this case, 19,513.31.
Yes.
Was the result of the input of what in this case was 39,084.00, which
Yes.
itself is dependent on the 48,720.
Yes.
And again, if you could give me the reference to that at some stage.
Yes.
It needn't be immediately.
Thank you. Seeing if the reference leaps out at me. Anyway, so that was the figure of 19,762, which, as I say, is derived from 10% on the previous year. And then if we go back to the supplemental bundle where that came from at page 107.
So sorry, I've just missed something here. It may not matter, but on the page we're just looking at, have been looking at, 107.
Yes.
You took us first of all to the owned plant with the 6% figure, and that produces 48,720. Then we've got the hired-in plant, which is a pretty small figure.
Yes.
And then we've got the plant overall, 39,084. But that's, I don't know what that relevance of that is.
Well, various discounts are applied
I see.
to achieve the resulting premium. The thing is, because there was no case advance that there would have been an additional premium, the evidence didn't descend in detail into how.
We don't know what the 39.
Well, it's
39
it's 80%, but we don't know
it's
any more
80%. I see. It's 80% of 48. Is it?
0.88
I see. Sorry, thank you.
in
very
just the
much.
same way as we had 95%.
We did,
in the subsequent.
Okay, thank you. It's a rather more startling figure, but it's 80%. I see. Yes. Thank you.
And the reason why I was cross-examining about mistakes was not because anyone was advancing a case that a different premium would have been charged, was that it was a key part of Zurich's case that the junior underwriters would have done what they ought to have done by referring it up the chain of authority so that the relevant decision maker was Mr. Penny. And one of the limbs of Niramax's defence, which ultimately was unsuccessful, was to say, well, because Mr. Penny didn't have any involvement until after the fire, he wasn't the underwriter at the time. One of the limbs of Niramax's defence which failed was to say, well, Judge, can you really be satisfied that they would have referred it as they say they would have done? Because look at all these other mistakes that they made. How can you be confident that if they had known this about outstanding risk improvements on the property insurance, that they wouldn't have just gone through and renewed it as they did anyway? Why would they have referred it to it all? And of course, if we had succeeded on that, it would have never got to Mr. Penny, and the inducement arguments would have failed completely.
Right.
So that's why there was exploration of the various mistakes that had been made.
Yes.
And so that was 107, and then if one turns on to 109, one can see how that translates.
Yeah. Right.
Sorry, it's back in the supplementary bundle at 109.
We noticed at 107 there wasn't the 1.4 uplift.
No, indeed. So that's the invitation to renew at the 19762 figure, which we've looked at 107, and that then appears on the policy schedule at 110. Same figure, 19762. And I asked Mr. Penny whether or not that was a correct rating of the risk, and he said it was. And I can take you to that in the supplementary bundle at 141. I'm sorry, there's a certain amount of jumping around between the documents. It's 141. Transcript reference 283 in the top left hand side. One of the muddles in all this is that when he had looked at the risk after the loss, the first time he was involved, Mr. Penny prepared a report which we have in the bundles, in which he expressed the view that in both 2013 and 2014, Zurich had missed the fact that this was a waste risk, which set a certain hare running. But in his evidence, he clarified that, in fact, that he was wrong on both accounts. At one point, he thought he was only wrong on 1 year, but ultimately he accepted he was wrong in relation to both years. In both years, it had been recognised it was a waste risk. So at 283, I was asking him about the 2013. And he says, sorry, I'll rephrase that. Sorry, that's not right, because I can see that it is actually rated as a waste risk. Sorry, I was wrong, sorry. So he's referring to his report. How can you see it's weighted as a waste risk? If you go up to if you go up page, it actually shows waste recycling risk. This is page 107 that he's referring to. We see the box, waste recycling risk. It's been rated as a waste risk. That's the 6%. That is the start rate, yes. If it was not a waste risk, that 6% would be lower. Is that right? Yes. It would be closer to 2% for a standard contractors plant. It varies by trade. So you've been a bit harsh on Sally Hudson there, possibly. I've been very harsh, actually. They did pick it up. So the upshot was that Niramax was paying the premium that Zurich thought was appropriate for a waste risk. Correct, yes. We then come to the renewal in the following year, relevant year 2014. If I can invite you again to turn back to that clip of contemporaneous documents we're in and look at page 112. I'm afraid these documents are just becoming a greater and greater challenge for the eyesight. If I can just tell you what this is a screenshot from an internal Zurich document and it's a communication from Gemma Jones, who was the trainee underwriter, who didn't actually have authority to write waste risks, but was doing it anyway, to James Trinham, who was supervising her, and it says, James, can you please agree the rate increase of 20% due to new claims 2013-14? Thank you, Gemma Jones. So that's the start of the process by which the premium for 2014 is calculated. And at 113 you have the similarly microscopic response from James Trinham. Gemma, I think that should be okay, to invite renewal at 20% increase as per rating sheet, regards James. And if one then looks at the document we're looking at, the rating sheet for 2014, should be page 115.
You described that as the starting point, but was there evidence that that was correspondence which preceded any population of the rating sheet?
Well, there wasn't evidence about the well. She refers to the rating sheet, and the figure of 23714 is in the bottom right-hand corner of the rating sheet. If one looks at 115, so that is how that figure has been achieved. It's simply a 20% uplift on the previous year.
I understand that, but was it possible to tell from the evidence as to whether that was the suggestion that she made at page 112 after she'd populated the sheet or before?
No, there was no evidence to that effect. Right. And it does create, you know, there is this certain oddity that on the rating sheet you have the various inputs and figures, but they don't actually lead to the figure at the bottom, the 23714.
Well, nor did they in 2013.
No.
But I can understand that if what you're doing in your rating sheet is giving yourself a band of acceptable
steer,
then if you're within that, being able to tell the client that it's around X% increase may well, in commercial terms, make good sense, rather than some precise figure with pence that, or without any mathematical reference. I can understand that. It doesn't mean that the rating sheet wasn't an important instrument in fixing the premium.
No, indeed. Yes, you asked, you had a query about the sort of target price and so on, and that was something I asked Mr. Penny about, and I can take you to that if it would help. In the supplementary bundle at page 248. Sorry, I think that's, just check my reference on that. So it's 132, I'm so sorry. It's the internal transcript reference, which is, I've given you.
Sorry, give me that page again.
So it's 132.
Thank you.
The transcript 248, bottom left-hand square, and I'm asking Mr. Penny about the difference between those different prices at line 14. You'll see there I ask him about the technical price, the target price, and the walk-away price.
So it's just a coincidence that the target price is 5%, exactly 5% above the technical price. According to Mr. Penny's evidence,
I'm
that
afraid
wouldn't necessarily be so.
none of us were clever enough to work it. Well, certainly I wasn't clever enough to work out it was 5% above or below. But
Anyway, that may not matter. It's the walkaway price which may be significant, and that's the absolute minimum.
And so that's why. I mean, in a sense, the judge was right to say there was a mistake on the rating sheet, because there was. It should have had 6%, not 2.25%, uplifted by 1.4. But because none of us went into the subtleties of how that translated into the premium, because the premium just wasn't an issue at trial, she perhaps understandably assumed that meant that had you got 6%, it would have been a higher figure. But in fact, it wouldn't have been a higher figure because 6% was in for 2013. The same sum insured, same hard in-plant rental, £3,000 a year, and what was in fact charged was 20% higher than that.
Well, that all depends on what happens in the gap in the computer, because I mean, I understand your point all the way through, but the evidence would seem to be that if you'd put in the 2014 schedule the right figures, you'd still have got a walkaway figure, and they would have charged a higher premium than that if it had been more than a 20% increase. And what we don't know is whether that would in fact have been so. We can't tell that, can we, just from the 2013 figure, because it has a whole lot of other inputs, which are quite different from the 2014 inputs.
Yeah, and they're, they're hidden in the computer and we don't know where they come from. And had Zurich ever advanced a case, we would have charged a higher premium. And of course, I would have explored with Mr. Penny, or whichever the technical underwriter was, quite how those figures were arrived at and so on. But none of that happened. That simply wasn't the case that was being advanced. So that was the process by which...
But sorry, your respondent's notice point, as I understand it, is if the errors in the 2014 sheet had been corrected, then that would not have led to a higher premium. And we can conclude that because we can see the right figures were put into 2013 and the figure was 20% lower.
Yes, I think I'd put it this way, which forgive me, may or may not be saying the same thing. The judge didn't have a sound basis for finding that if the inputs into the 2014 premium had been the 6% figure, rather than 2.25% with a 1.4 uplift, there was no evidence before her that that would have led to a higher premium than the 23714 that was charged, which was the product of 20% on the previous year, which did include 6%.
Say for the very end of that answer we had from Mr. Penny, which may have been referring to the effect it would have on the intermediate figure rather than the effect it would have had on the final figure. But he did say it would lead to a higher premium.
Yes.
At 2.3. At 141 of the bundle. Page 285, line 7.
Yes, that's, see, this may have been the source of the judge's error, because he says, correct, yes, that is why his premium is lower than the previous one, when in fact it wasn't. He had assumed it was, because 2.25% was used in 2014. But in fact, as we've seen, the premium in 2014 was 20% higher than 2013.
Well, he may just have been talking about the premium at the intermediate stage of the 18,000 rather than the 48,000.
Well, at this stage, I hadn't asked him any question. I wasn't asking him about the intermediate stages and so on. Again,
I see. Okay.
What I was referring to here was, again, Mr. Penny's mistaken belief that there had been a failure to spot in 2014 that this was a waste risk. And that's why at paragraph 19, he'd mentioned that earlier in his evidence, and that's why at line 19 on 284, say that's the bit that you've now spotted that you previously missed, which shows that Michael Smith increased the premium because of it being a waste risk, because that's not what he'd said in his report. Yes, I'm not sure why he's done that, because at this point he could have picked waste as a trade, i.e. he could have just picked waste on the drop-down menu to give the 6%. He's actually picked contractor's plant for some reason, I don't know why. There are two different ways of taking account of it, but he's adopted one way. Yes, the correct way of doing it is to use the waste recycling trade, i.e. that gives you the 6%. So he's correctly identified it's a waste risk, but he's not performed this calculation correctly. Correct, yes, which is why his premium is lower than the previous one, and that's where he was simply wrong about that. It wasn't lower than the previous one. But again, I mean, what these lines of questioning were addressing was generally the competence in the underwriting process, and the confidence the judge could have that one premium, that any underwriter would have referred matters rather than just spitting out a premium had they been aware of other matters. And if I can just take you to a final bit before we break. So that led to the figure of the 23714, which is in the policy schedule at 117. And when that premium was quoted to Niramax, its brokers raised a query with Zurich about that. And if I could, as the last reference of the morning, take you to that, which was explored in evidence at page 185 of the bundle. In the top right hand corner of page 458, starting at line 3, this is a note that was made within Mr. Sweeney's office, who's Niramax's broker, and what's recorded is the renewal terms. That's the figure that we've seen on the rating sheet with the 20% increase. Yes. I spoke to Gemma Jones at Zurich. I assume the only Gemma Jones at Zurich I am. Well done, yes. Refer to senior underwriter, but they will not reduce the premium due to the 3 claims in 2012 and the 8,400 claim in February 2014, also due to the trade. And also due to the trade was reference to the fact it was a race risk. Yes. And Zurich knew that the waste risks were high risk. Yes. And that's why they charged more for them. Yes. So the broker challenged the premium, and what he was told is that it was due to the claims experience and the waste risk. And so the challenge to the 20% uplift on the previous year was unsuccessful, and the premium went through at that price.
Well, if that's a convenient break, we'll carry on at 2 o'clock. Thank you very much.
All right.